and welcome to today's program titled The Biden Administration Enforcement Actions Affecting Labor and Employment. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them in the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and is required for CLE credit. Copies of the webinar, recording, and materials along with the CLE attendance form will be distributed to attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. At this time, I would like to turn it over to our opening speaker, Scott Hecker. Scott, please go ahead.
Thanks, Kate. Welcome again, everyone, to today's Seyfarth webinar. I'm Scott Hecker, Senior Counsel in Seyfarth's DC office, focusing on workplace safety, wage and hour, and government relations and policy issues. I came to the firm after about a dozen years at the U.S. Department of Labor, where I held various positions in the Solicitor's Office and the Wage and Hour Division. Yesterday, as many of you probably know, we received some timely L&E news out of the Senate as Secretary of Labor Marty Walsh was confirmed with bipartisan support, 68 to 29. As you'll hear over the next hour, Secretary Walsh immediately has a lot on his plate. We have a great group of experts with us to discuss the Biden administration's enforcement efforts in labor and employment, and we expect to cover a lot of ground today. First of all, we have Chicago partner Annette Timon, who provides counseling and litigation advice to employers that leverages the use of data analytics, emphasizing pay equity, diversity and inclusion, and people analytics to develop data-driven solutions that solve complex workforce issues. Atlanta partner Kevin Young provides sage counsel and, when needed, high-stakes support to employers in the wage and hour arena. And Dawn Lurie, my fellow DC Office Senior Counsel, delivers seasoned strategic counsel to employers navigating the legal risks associated with I-9 and immigration compliance. Hey, if we could go to the next slide. And you'll see the agenda here. It's pretty packed. Annette will handle the EEOC and OFCCP materials, followed by Kevin discussing Wage and Hour Division enforcement. Then Dawn will talk to us about immigration, and I will wrap it up with some OSHA topics. So if we could go to the next slide, I'll turn it over to Annette.
Terrific. Thank you, Scott, and welcome to everybody who is joining us today. For purposes of the section that I'll be talking through, I'll be giving you kind of an update on the EEOC overview, and as you'll see from the next slide, there have been some immediate changes, I would say, even since the last presentation. For those of you who have been part of the series that this group has brought together, earlier in March, the general counsel's vacancy opened up, so we definitely saw some changes there. Sharon Gustafson, her term was supposed to expire in 2023. She was removed by President Biden, who, as we had seen with other agencies, it's been a little bit unusual. Her term was supposed to end in 2023, and she received a letter asking that she step down from her role, which she declined to do and was removed. So that general counsel position remains open. As you'll see with the rest of the makeup since our last update, that has remained the same. It's certainly interesting in terms of what the limits or limitations are that this current administration can do with the EEOC's current makeup, given that the first commissioner to fall off on the Republican side is going to be Janet Dillon. So until July of 2022, we're really not going to see, unless there's further changes, we're not going to really see a shift. So we'll be guided somewhat by prior administration, given that the commission on many key issues operates, by committee in terms of voting. So that is an update for you that we wanted to share. And then if we go to the next slide, there has been additional action for those of you who have been following. There was a collection of pay information pursuant to the EEOC's authority to collect data. And for 2017 and 2018, employers had to submit compensation data. In the prior administration, there was the decision that the EEOC's data, the collection of information that had been made on behalf of employers across the country, would not be shared with us, with the state FEPs, so the state essentially arms of that would investigate EEO-related issues. So what happened was I would say October of 2020, I believe it was, the state of California and other states, including Maryland and Minnesota, sued the EEOC to collect that data pursuant to the work sharing agreement, and wanted to make sure that they still had access to that information. So that litigation had been going forward. In just the last month or so, Chair Burrows requested a review and just asked for a stay of the decision making and, kind of next steps, as she said that she was revisiting the data sharing policy that was at issue in the case, and to the extent that there were changes, it might moot the entire litigation. So what that means is that potentially the data that the EEOC has currently, historically said they would not share with the state fair employment offices, there might be a shift in position, and they may be in a position where they're sharing that information statewide. The other update I would provide on the next slide with regard to the EEOC specifically is many employers across the country are working on the EEO-1 submissions that are due for 2019 and 2020. There has been a shift there. And the EEOC, normally we'd be getting all the filings completed by the end of March, and that has changed. The agency has said that they will be opening their online filing collection tools in April. We're not exactly sure the date, but new information will be available. And the agency just posted additional information that the data collection portion would close in July. So that's coming up very soon, and I know that many employers are working on that, along with some state filing issues that they're working on. So that's just a quick update on the EEO-1 submission process for 2019 and 2020. And if we go to the next slide, we can go ahead and start talking about the EEO legislation, so key issues. The reason I'm going to highlight three pieces of legislation, and the reason why I'm identifying those is because just last week there was a hearing before the Committee on Education and Labor Subcommittee on the Civil Rights and Human Rights Services Subcommittee on Workforce Protections. They covered four pieces of legislation. I'm going to highlight three of them that are being considered. The first, and I think probably the most critical, is the Paycheck Fairness Act, which is H.R. 7. And it would essentially amend the FLSA, the Fair Labor Standards Act, and would really limit in many ways the defenses that employers can make, and in particular, for all intents and purposes, essentially eliminates that factor other than sex, or makes it so difficult that it would be very difficult to use that factor. It would also prohibit an employer from seeking or relying on prior pay information when extending a job offer, and we have certainly seen that trend across many states, but this would make it a federal requirement for all employers. It would also impose unlimited compensatory and punitive damages, and would also make it much easier to bring a class certification or class action issues. It would also require data collection. So as I mentioned in the earlier section on that pay information, the prior administration had stopped the collection of pay information from employers pursuant to the EEO1 data collection tool that they had been using, but this would now revisit that, and it would require the EEOC to again begin collecting it. It doesn't exactly say how they should collect it, but that would be an additional data collection point that the EEOC would be required to engage in. So that is out there. I will say that tomorrow is Equal Pay Day. So, you know, I have heard reports that there might be some additional action coming out potentially tomorrow. So be on the lookout and be on alert for any changes on particular at the federal level. And with that, then we'll move into the next area, which is the Protecting Older Workers Against Discrimination Act. And that one was introduced in the House in February of last year and passed the House. It was reintroduced March of 2021, just last week. And that hearing really touched on what the issues are facing older workers, and it would essentially amend the ADA, ADEA, the Rehabilitation Act, and Title VII. And really what it's doing is introducing the mixed motive theories, and basically saying that any factor, if age is any factor in the employment decision, it would allow for liability in those areas. Now, interestingly enough, Camille Olson from I should have mentioned that in the hearing that occurred last week, Camille Olson, who's a partner at our firm, testified on all three of these laws that I'm going to give an overview on. And one of the key issues she talked about was that, you know, there's no individual remedies that would be available. So in addition to making it much more difficult for employers to defend on these issues, it also isn't really going to be a ton of benefit for an individual plaintiff, but it would increase certainly attorney's fees, and it would allow for a declaratory relief as well. So there's a lot of interest around that specific piece of legislation that may be coming down the pike. And then the last one, and if we go to the next slide, I'm not sure if we skipped the slide, but it was on the Pregnant Worker Fairness Act. And that one is essentially a bill to prohibit employment practices that discriminate against making reasonable accommodations for on the basis of pregnancy. So it would essentially bring to bear many of the Americans with Disability Act issues, which currently would not necessarily protect pregnancy as a disability, but this would incorporate many of the same provisions, require that interactive process, allow for reasonable accommodations for pregnancy, and certainly would, it also deals with retaliation issues. So those are three of the key pieces of legislation that are coming down on a federal level, or at least being discussed on a federal level. Pay, I think, is going to be one really interesting piece to think through as we move forward in the Biden administration. Certainly, Vice President Kamala Harris had a lot of initiatives, very specific and very focused when she was in her run for presidency. If you may recall, that was part of her platform, was pay equity issues. So we do expect to see some movement on that front. So with that, we will touch base on the OFCCP overview. And I believe at the time of the last update that we provided to you, Jenny Yang had already been appointed as the OFCCP's director. As you may be aware or may recall, Jenny Yang was an EEOC, former chair of the EEOC, and she has a very interesting history, employment history, in terms of where she has worked and the kinds of issues that she has championed in the past. In particular, she kind of has a trifecta when it comes to working on OFCCP issues, given that she also worked at the Department of Justice. She has background as a plaintiff's lawyer. She also, after she left EEOC, spent some time working at Working Ideal, which is a consulting company. So she has a lot of experience and understands the political sort of space and sort of how to move. And so for federal contractors, this is really important, right? Because she was certainly a champion of the data collection on pay issues. She is and very focused on some key strategies that employers are facing. So we've already seen some changes that are coming down. Certainly a move from employer assistance or compliance assistance to more a shift to enforcement is what we're definitely seeing. So a couple of things that are giving us sort of that direction is she has made a change to remove the focused reviews and compliance checks, which were some audits that were being done under the former OFCCP director's requests and changes that we saw there under Craig Lean, who was the OFCCP director. And so we've seen those were audits that didn't it was interesting because they were intended to provide additional guidance. At least that was the messaging. And there wasn't monetary penalties, essentially. And so now those have been removed completely from the OFCCP's scheduling audits. And so it will give the agency more time to do additional audits that have that carry with them, financial penalties. They also discontinued the compliance assistance portal. What they had seen was there weren't very many employers that were utilizing it. So again, the costs weren't justified by the expense or the benefit to employers. So they have focused their attention. And then the one piece that we're interested in, watching on a go-forward basis is a plan that had begun under the prior administration to require all federal contractors to make certain statements about essentially verifying their compliance with affirmative action requirements. There has been a notice posted on the OFCCP's website that said essentially this interface is coming. So we're waiting for, additional guidance and information about when that's going to be starting, but it essentially would require federal contractors to affirmatively go in and state that they are in compliance with the requirements of their obligations, both for direct federal contractors and subcontractors. And we believe that that is going to be an additional tool that the agency is going to use as it selects additional contractors for audit. And I will wrap it up by moving to the last slide, which will just touch base on a couple of things I've already mentioned, which was the compensation. So certainly more from OFCCP on compensation data and transparency. We're believing that's coming forward, as well as the systemic pay analyses. The other big issue that was a very, very big interest to Director Yang when she was at the EEOC is the issue of artificial intelligence, especially in the recruiting process. So we will see what she ends up doing on those issues. She was just on an HBO special that dealt with testing, and it was the name of the program, it's called Pursuant, an HBO documentary that she was just on. So it's pretty interesting to see her personal views on it, and certainly more to be found. The rest of it, the OFCCP certainly rescinded some Obama-era executive orders, and the agency has fallen in line with that. I believe that was already part of the last update, so we won't go into that. And we will now move forward with the Department of Labor and Wage Hour Division discussion.
Thanks, Annette. And Kevin, right before you get going, let me just remind people that we do have a chat function available for folks to submit questions. A few of our attendees have already figured that out. Most likely, based on time, we'll reach out to you individually after the program with answers. But if you have anything that comes to mind during the presentation, feel free to submit through the chat function. And I'll turn it back over to Kevin.
Excellent. Thanks, Annette, and thanks, Scott, to you and your team for putting this together and inviting me to speak, and also for giving me a reason to dust off the blazer after about a year in the closet, give or take. So for the next few minutes, I'm going to focus on what types of activity and change we expect to see at the Wage and Hour Division, which I'll sometimes slip into calling WHD. I'll try not to, but it's likely to happen at some point. A quick and probably unnecessary point, but I want to make sure that we're all playing from the same sheet of music about who the Wage and Hour Division is and what it does. So the Wage and Hour Division is a division of the Department of Labor. It's responsible for enforcing a multitude of labor standards, but the most notable one for sure is going to be the Fair Labor Standards Act, including the minimum wage, overtime, and child labor provisions, as well as the FMLA. The Wage and Hour Division has authority to enforce the FLSA, which it generally does through investigations or litigation, and it also has authority to issue guidance, and also in tandem with the Department of Labor regulations concerning these laws. As we look ahead to what might be in store at the Wage and Hour Division, I thought it'd be helpful to come at the topic from 3 different angles. One, who are the key players that we know about so far at the Wage and Hour Division and at the Department of Labor? Number 2, what enforcement methods do we expect to see them utilize? And then number 3, what substantive issues do we expect them to focus on? As you'll see as we go through it, I think these 3 topics, the people who are there, the tools that are available to them, and the substantive topics that they'll focus on are really interrelated. If there's a theme to all of this, I think that it could be summed up in 2 words, which is that I'd say buckle up. I think that there's going to be a lot of activity as this administration settles in, both undoing certain guidance and stances that were taken by the Trump administration, and then rulemaking and issuing guidance on those same very issues in the months and years to come. So with that, we're already on this first slide I wanted to go through. So first wanted to focus on who are the people that we know are going to be there. We've listed on the slide the key individuals that we know about so far. A common thread you'll see if you look at these folks is that they hail from states with pretty progressive employment laws and enforcement approaches. How that translates to the national level is anyone's guess, but it's certainly an important backdrop here, I think, to keep in mind. As Scott mentioned at the outset, so Marty Walsh was confirmed yesterday by the Senate as the Department of Labor Secretary. He should be sworn in soon. I don't know the exact date on that, but a few key points about him. He's an organized labor veteran. He pushed for paid family and medical leave for Boston City employees when he was mayor of Boston, and also had a very strong focus on pay disparity, both gender and racial. And he's a longtime friend of President Biden. I think that last point is pretty important. Certainly, I don't think there's any presidents who are bringing in agency heads who they dislike or who they don't see eye to eye with. But there's really a personal relationship here between President Biden and Marty Walsh that I think should prove important and relevant in the years to come, where it would be fair to expect a sort of collaborative approach between the two. Next is Deputy Secretary Julie Su. She, if confirmed, would be the number 2 at the Department of Labor. She's currently she's being reviewed by Senate committee, and she's showing a lot more resistance than Secretary Walsh did. So it'll be interesting to see how her nomination proceeds. But Ms. Su is a lawyer and a smart one at that. She's from California, has a lot of experience in different facets of employment law at the state level. Based on her past statements, which you kind of take them for what you will, she certainly seems to have the view that California is a sort of flag bearer for the rest of the country when it comes to employment standards and innovating on that front. Another thing that I think is really important to note about her is that Ms. Su was heavily involved at the state level in future of work type issues with a specific focus on automation and how that could impact certain workforces and trying to plan ahead for that. 2 other individuals I wanted to mention very quickly. One is Senior Counsel Patricia Smith. So Patricia Smith was the Solicitor of Labor under the Obama administration. Solicitor of Labor is basically the top lawyer at the Department of Labor. She's now come back as Senior Counsel for the new administration at the Department of Labor. I think it's fair to expect that with Ms. Smith's return, you would see a return also of some Obama era, maybe not policies. I think it's going to be for this administration to decide what their policies are going to be, but at least enforcement approaches. How do they go about getting the job done? So her appointment is certainly helpful or at least relevant to note. And then the last thing I'll mention, and probably most important if we're focusing on the Wage and Hour Division, is that there's no administrator yet in place at the Wage and Hour Division. The division has 2 deputy administrators, and one of them in the interim has been appointed as principal deputy administrator. Her name is Jessica Lumen. She's from Minnesota, has a lot of experience and Minnesota employment law issues. Well, Minnesota is not California or New York or Massachusetts from an employment law perspective. It does have some some cutting edge things going on the employment law front, not the least of which is that the biggest city, Minneapolis, has enacted a $15 minimum wage. Our minimum wage that's going to reach $15 an hour over time. So with that, those are the people who are in place. Now let's go to the next slide. Let's talk about some of the tools that are available to them. Okay, so I wanted to focus on, so we know roughly at least some of the players who are in place right now. What are the tools that are at their disposal to get the job done, to take policy and to implement it through their actions over the next 4 years or more. Generally, the Wage and Hour Division's enforcement efforts can be broken into 4 categories or 4 buckets, and I've listed them here on the first column. One is rulemaking, issuing regulations and things like that. The second is opinion letters, the vehicle by which an employer can go to the Department of Labor and to the Wage and Hour Division and ask for an opinion on a specific practice. And that opinion, once the employer receives it, can act as an absolute defense in the event of litigation. So that's another one. The third, and probably the most notorious or prominent, depending on who you're asking, is investigative actions, the ability of the Department of Labor, either with or without a complaint, to walk into an employer's place of business and to essentially ask them to open up the books and to conduct an investigation for compliance. And then the last one I'll mention is voluntary compliance initiatives. So how do we expect the Biden administration to approach these tools? Because though these sorts of tools are available to each administration, administrations differ in terms of how or even whether they use these sorts of tools that are available. To add some flair here, and in the spirit of March Madness, I've tried to approach it from a betting perspective. What are the safe bets here with respect to each of these tools, and what are some bets that, a little bit more tenuous, kind of more trying to read the tea leaves, but we're not quite sure yet. So first, let's focus on regulations and rulemaking. The new administration, the new Department of Labor administration has already taken steps to rescind the Trump administration's rules concerning independent contractors and joint employment. The joint employment rule had been largely vacated by a New York federal judge. I think it was late last year. But nevertheless, the Biden administration has made clear that these rules that the Trump administration issued are likely not going to go forward. I think where it's at right now is there's a proposal to rescind these rules. I'd be extremely surprised if that proposal did not result in the actual rescission of these rules. The independent contract rules, as some folks might remember, essentially paved the way for a clearer analysis of who's an independent contractor and who's an employee under the FLSA by focusing on a more narrow set of factors than has typically been the case, and also by making clear that the focus should be on the actual exercise of one of those factors. So if a factor is control over a given worker, the rule that the Trump administration had issued said, look, we're not looking at the opportunity or the theoretical capability to control the worker. We're looking at actual control, that sort of thing, which was not the case under the prior administration's view. Similarly, on the joint employment front, what the Trump administration had said with its rule was we're going to have a more narrow set of factors that matter to the analysis of, is a given business a joint employer under the FLSA? And also we're going to require that businesses actually act in furtherance of one of those factors to be an employer. Those rules are not going to be on the books this time next year. I think that's a pretty safe bet. And where the DOL goes from there is, I think, a tougher question. I think it's fair to assume that the Department of Labor is going to turn its attention after rescinding these rules to what's the proper analysis for an independent contractor classification, and probably also looking at joint employment issues. I think also when you think about the fact, particularly that with Julie Su coming in as number 2, assuming she makes it through, with her focus on the future of work in California, and with just the issues that have swirled around California for so long, I think it's fair to expect that there'd be some focus on gig economy issues over the next several years. One thing I put down here that I think will be interesting to watch, in California and in Massachusetts, you have states where there's been some semblance of what's referred to as the ABC test. This test that makes it essentially very difficult or much more difficult to classify a worker as an independent contractor rather than an employee. Both California and Massachusetts have had those an ABC test on the books at various points in the last several years. You've got Marty Walsh coming in from Massachusetts. You've got Julie Sue probably coming in from California. Does that translate to some talk of an ABC test on the Hill? Who knows, but I think it's something that'll be interesting to watch. The last thing I'll mention here, I'll move quickly on from here. You know, on the regulation and rulemaking front, I think it's fair to expect the Department of Labor is going to work closely with the Biden administration on minimum wage increase efforts. It's something that Biden has voiced support for, and it's something that Marty Walsh has voiced some support for as well. And I think that could also eventually be true with respect to paid family and medical leave, which is something that, again, Marty Walsh pushed for very hard in Boston when he was mayor of the city. The sub piece of minimum wage change, I think that'll be really important to watch for certain employers is what do we do with tipped employees? Looking at who can receive this lower tipped minimum wage of $2 and change per hour, and also whether that sort of wage is even available for certain tipped employees has been a little bit of a political football the last few years, and it's something I think could certainly receive some focus. I'll move quickly through these last ones. So opinion letters, the Trump administration was made a very prominent use of allowing employers to come to the department and seek an opinion letter on a specific practice. There are a lot of opinion letters, I think it's close to 90, I might be a little bit off on that were issued over the 4 years of the Trump administration. The Department of Labor under the Biden administration has already rescinded 3 of them, including one opinion letter that was seen as pretty pivotal or monumental in the gig economy space. I think with Marty Walsh coming into the fold, I think it's fair to expect that the Department of Labor is going to continue to rescind and evaluate, or I should say evaluate and rescind other opinion letters. Which ones it rescinds is something that remains to be seen. A bigger question to me, and something that I think just remains to be seen in this middle column, is, are opinion letters a thing under this new administration? It was not a very common tool under the Obama administration, and even if employers have that available to them, I think there were fair and tough questions about, do you want to be the employer that's going to the administration at that point in time asking for an opinion on a certain practice? If the Biden administration goes away from the opinion letters, it's possible that we could see a return of administrator interpretations, which was popularized during the Obama administration. Essentially, it's this sub-regulatory type of guidance where it's not an opinion letter, it's not regulation, but it's an opportunity for the Department of Labor to opine broadly on a specific issue. They were attacked under the Obama administration as being essentially an end around on notice and comment rulemaking, but it doesn't mean that this new administration won't consider using that sort of guidance as a way to speak in big, broad strokes to big and important issues. The last 2 things here I'll mention very quickly. Department of Labor investigations under the Trump administration, they were still happening. I think it's a common misconception that Republican administration investigations aren't going on. The reverse was true. The Trump administration during fiscal year, I think 19, I think it was a new high at that time for back wages recovered by the Wage and Hour Division, so there was still activity going on. But certainly under the Trump administration, there was more of I'd say a softer approach to those investigations, and I think Exhibit A of that was that the Trump administration all but took the possibility of liquidated damages off the table in the context of investigations, unless it was just really egregious or repeat type violations. The Biden administration has already walked away from those sort of pronouncements, saying, look, when we investigate, the full range of penalties is available. We can go for liquidated damages, we can go for civil money penalties, that sort of thing. And I think it's fair to also expect that as active as the Trump administration was on that front, the investigation activity will be even more prominent, even more voluminous over the next few years. So the very last thing I'll say here, voluntary compliance initiatives. The Trump administration had set up this program called PAID. It was essentially a voluntary compliance program If you ever want to hear details about it, you can ask Scott Hecker on this cause, very near and dear to his heart. But it was a program that essentially allowed an employer to conduct a self-audit, come to the Department of Labor and say, hey, we found this, we'd like to resolve it. We'd like to go ahead and pay back wages. Allowed the employer to get peace of mind in resolving those sorts of claims without having to pay liquidated damages and without having to worry about an employee turning around and suing for the exact same issue. The paid program, I believe it over the course of its life, got about $7 million out to about 11,000 workers, but it's now been canned. The paid program is no more, and I think it's pretty unlikely that we'll see a voluntary compliance initiative program propped up anytime soon. With that, and just one final point as we go to the last slide for me, on that paid program, and I think also when you think about increased wage and hour division investigation activity, and also a wider array of penalties and damages for investigators to throw at employers, I think it's more important than ever for employers to have the house in order, so to speak. Who knows who's going to get an investigator come knocking, but we think it's going to be more active. We think it's going to be a little bit less friendly than it's been over the last 4 years. So certainly I think making sure the house is in order now is certainly a good order of business. The last thing, I won't hit any of these points too hard because I think I've covered them, is the substantive issues that we expect the Wage and Hour Division to focus on. Certainly, as I mentioned before, I think independent contractor and gig economy issues will be a focus at some point for this administration. They're rescinding rules now, but I think new rules and new guidance is going to be coming. I think with the focus on the future of work, it's also fair to wonder, is this administration, is the Wage and Hour Division going to focus also on work from home? The workplace has evolved so quickly over the last year and so far afield from what the FLSA ever imagined. So I think that could be a focus for sure. Minimum wage issues, again, would not be surprised to see the Department of Labor working in conjunction with President Biden and Congress to try to push that through. And then lastly, as I mentioned before, and it's been mentioned already, Mayor, now Secretary Walsh, has advocated for paid family medical leave in the past, and is also a big proponent of enhanced pay equity measures. Wouldn't be surprised to see him continue to focus on that in Washington. So I apologize if I'm a couple minutes over. Hopefully this was informative, and I'll turn it over from there.
Thank you. All right, we'll go into the next slide. So we're going to turn to immigration enforcement at this point. So when the election happened, actually, let me take a step back. When President Trump was elected, I remember there was a lot of chatter. Employers were very concerned about immigration enforcement, worksite enforcement, raids, things like that. And I remember talking to people that we knew at the agency and just kind of doing due diligence. And, I said to myself, I don't think we're going to see a ramp up right now. I don't think this is where the president's going to focus. And, there was a lot of blogs and employers were just, scrambling, thinking ICE was going to be knocking on their door. I knew we were going to see notices of inspection on the I-9 audits, but fortunately I was correct. We did not have a huge number of worksite enforcement actions. There were some, but it did not resemble the Bush administration under Secretary Chertoff and then Assistant Secretary Julie Myers-Wood. It was very different. So when Biden was elected, I sat again with my partners, and there was kind of a sense of relief, saying, okay, we're not going to have enforcement now. And this time, I said, I don't think that's going to be the case. I think we're actually going to see more enforcement in a different way. So today, we're going to kind of talk about what the business community can expect, where things are. And while my focus in particular is on enforcement, E-Verify, I-9, anti-discrimination issues, I'm also going to touch a little bit just on the straight immigration because everything flows, including obviously the DOL work that we do. So one of the things that right now are still kind of be in the bonnet of many employers is the fact that we still have a non-immigrant travel ban. So in December, President Trump extended his non-immigrant travel bans and his immigrant travel bans. President Biden came in and employers were hoping that we were going to see both bans listed, but unfortunately, that did not happen. So individuals that are able to get immigrant visas are able to come in, but the non-immigrant visa ban is still in place. And so right now, I think that caught some people by surprise. Fortunately, this will be up at the end of March 31st. Now, it is possible that President Biden could extend that ban, but hopefully unlikely. Again, these were put into place because of the supposed economics, the issues that American workers were supposedly facing, and then of course all of the COVID health concerns, the related health concerns. Right now, I think that we're going to continue to see this mix of enforcement and a focus on a certain type of immigration. The priorities have definitely been outlined. Can we go to the next slide, please? On the Hill as well as at the agencies. So just last week, we saw that the House passed the American Dream and Promise Act, the Farm Workforce Modernization Act. We know that President Biden and the leadership that he's chosen is very focused on getting something through for the DACA, for the Dreamers, for those individuals that were brought to the United States without, at a young age and through no fault of their own are still here. It's a hard place that the administration finds himself in. Just before the webinar, I was looking online, and I saw some photos that the congressman from Texas had released. Queller had released. He was down on the border and was showing the state of the unaccompanied minors that are being held there in very close conditions, and it's a problem. I don't think the administration was expecting this, President Biden is certainly emphasizing the humane treatment of immigrants, and they don't want to be particularly looking at their legal status, whereas prior Democratic presidents really, I think, certainly saw the need to balance. I think there was, President Obama once said that we simply cannot allow people to pour into the United States undetected, undocumented, unchecked. And the reason I share this, I think those of you in the business community say, well, there's not that much overlap. There really is, because this is where the resources are going, and this is where right now the focus is. Now, litigation in the business community, it's critical. It remains critical. It was critical. We have to keep hitting hard. And we are seeing that this administration, they really don't have the stomach to be defending all of the Trump era rules and regulations. The chamber's litigating, ALA's litigating, individuals, there are many, many, many different agencies and groups. Everyone's talking about policy, what's going to happen. We have the U.S. Citizenship Act of 2021, a lot of changes. So we have to watch this because there's a lot of enforcement, kind of baked in. Are we going to see, where there's going to be some give, where if we do this on the enforcement side, we'll then get this? I'm not really sure. Next slide, please. The prior administration had effectuated the Buy American, Hire American Act, and that particular focus of the Trump administration was to protect U.S. workers, promote job growth, and protect the integrity of the U.S. immigration system. Very early on in his presidency, President Biden signed Ensuring the Future is Made in All of America by All of America's Workers. And basically, in addition to the other things that it did, it revoked the Buy American, Hire American executive order. And that's important. Next slide, please. Because that really drove drove much of the focus on enforcement and immigration. It drove things in the Department of Labor, it drove the Department of Justice, the Immigrant Employee Rights Office, and basically we saw that particular office was, targeting and investigating employers that were discriminating against U.S. workers, especially over temporary workers. It's interesting because when the Trump administration had come in, there was talk that the Immigrant Employee Rights Office, I'm going to call them IER, really wasn't going to be busy for the next 4 years. I never thought that was going to be the case. They were very busy, and not just on, the protection of U.S. workers, which certainly was a goal, but just really across the board. That agency was run by, ultimately by Assistant Attorney General Eeoc Overview and the non-political individuals that were still there. They had a focus, and they continued to stay the course and to bring claims against employers that were discriminating in either way. We are already seeing cases come out. There has already been cases at the end of January, the beginning of February, where we're talking about national origin discrimination or citizenship status discrimination. So we do believe, in terms of enforcement, that office is going to stay busy. We think that they have a large number of resources, and we're going to continue to see that they enforce the anti-discrimination provision of the Immigration and Nationality Act. So right now, we have a lot of employers that are interested in focusing their job applications and rewording, perhaps saying we're only going to have U.S. citizen-only hiring policies or U.S. worker hiring policies, or we're not going to hire H-1Bs. And of course, there are still ones that maybe prefer H-1Bs. It's time to be really careful with that, because we need to ensure that employers are consistent in whatever they do. I think that companies are concerned that that they're bringing people back from furloughs, or they still have companies on furloughs. How can we deal with foreign workers? But at the end of the day, we still have a huge number or a huge amount of foreign talent in the United States that keeps us competitive globally. So there has to be a balance. And this office, as I said, I think they're going to continue down their, on their wagon, their bandwagon of enforcement. But I do think that they are looking for employers that have inconsistent policies or are trying to undercut certain the ability for U.S. workers to apply in such a way that there may be some preference to foreign workers. So we want to keep our eye on that. Let's go down to the next slide. All right, so USCIS, it's been a hot mess. That's, a very technical legal term that I like to use, and I hear that it is still a hot mess. I hear that, there are files all over, and they can't feed, I know they can't feed things in fast enough. There are issues with the lockbox. Those of you that are involved in the day-to-day immigration, we're having issues getting work authorization because we can't get receipts on time. It's hard, and as much as some of us would like to blame the prior administration, that's not necessarily the case on certain things. It's going to be hard, but I think they are going to dig out. So what we're starting to see now are some of the Trump era policies being undone. Now one of the three core things that Baja did with CIS was the rescission of the deference memo for extensions in the H-1B and the L-1B, the L-1 categories. In other words, for individuals that were already in the categories, normally if you were in it, you were already qualified, and we didn't see somebody looking underneath, but we saw a lot of looking underneath, a lot of requests for evidence, a lot of time and money and effort, and just really an attack on our foreign workers that really keep our economy going and are going to be so critical as we come out of COVID and begin to recover. Same thing, the rescission of the H-1B third-party worksite memorandum. We saw an enhancement even during COVID of FDNS and their site visits. So all of that is being undone. It's being unraveled. They're pulling slowly. But again, keep in mind the priorities that I told you at the beginning, right? They're just getting people into their jobs. They're, trying to take a look and see what they have on their plates. And I think business is still taking a second seat. That said, we know that that leadership and including policy, including people that are have been there, they're non-politicals. They understand the importance. and as I said, they're not interested in necessarily litigating and defending the prior administration. DOL, you heard a lot about DOL on from our prior panelists, and I think this agency in particular is going to continue to focus on what's important to them. And I think that organized labor is really, has a loud voice in this administration. There's a lot of input there. And I think that, one of their priorities is going to be to ensure the H-1B allocations, and the priority will go to the individuals with the higher H-1B salaries, right? So we know that's floating around. Again, I don't want to get too far down in the weeds, but I don't think that's going away, and I think we're going to continue to see that. So next slide. The focus of my day-to-day is on ICE and worksite enforcement. And those of you that attend my, our worksite and enforcement and compliance group here at Seyfarth have heard me say that I once heard someone high up at ICE say, the agency is like an aircraft carrier. So every 4 years or 8 years, maybe we take a turn 5 miles to the left, maybe we go 2, but at the end of the day, we stay the course. And I think that's, that's been the case. Worksite enforcement has gone up and down in the past, 20 years. But I do think that the goals still remain the same, and I do not think the Biden administration will be changing that. Protecting the nation's critical infrastructure, reducing illegal employment, and protecting opportunities. So, folks, we are going to continue to see notices of inspection. By the way, we already have clients that are audited, right? So last month, we started to receive I-9 audits. So if you think because of COVID, just not the case. We've already submitted a round. We also are seeing them go through some of the older audits. ICE is going to continue on their enforcement mission in terms of enforcement, compliance, and outreach. I don't know what's going to happen with the outreach program, which is kind of it's called their image program. We can go to the next slide. It was attacked in the January OIG report. And I'm not really sure whether or not they'll beef it up under this administration. It's something to consider. It includes, it's a litany of best practices, E-Verify, undergoing an audit and then not being audited by the agency. It also, under the last administration, the Worksite Enforcement Group out of Homeland Security Investigations actually sweetened the pie. They allowed kind of like a voluntary disclosure. If you came forward to them before you were in trouble, they would forgive certain things that were otherwise, perhaps systemic electronic I-9 issues. So look, I want to be cognizant of time and try to let Scott catch up here. So I'm gonna close out there, but just to remind everyone, keep your eye on the ball here, because I don't think this administration is going to be focusing on we're not going to see the raids, we're not going to see those early morning helicopters landing and individuals, non-citizens being rounded up. But what we are going to see are employers being targeted for not doing what they need to do. I mean, Biden has already said we're going to punish egregious employers. So for those of you that are trying to do everything right, check under the hood, clean your house. Now's the time to do it, and make sure that those agencies don't knock when you're not prepared. Thank you.
Thanks, Dawn. Appreciate it. I'm going to take the last 6 minutes or so to try to talk through some OSHA issues, but first, I wanted to share our CLE code. It's SS, as in Seyfarth Shaw, 7334. Again, SS, as in Seyfarth Shaw, 7334. If we could go to the next slide, just speaking about the emergency temporary standard, all of you who are waiting with bated breath for the March 15th deadline were sadly disappointed when OSHA blew through that. Many still, and I'm one of them, expect that the ETS will still be issued. Whether or not that is a smart move, we can leave for another discussion. But as of 8 minutes before this webinar, the Office of Information and Regulatory Affairs website doesn't indicate that the standard's under review, meaning OSHA has not sent it over to the White House for approval. And unions and worker advocates remain hopeful that an OSHA ETS will contain some of Cal OSHA's more problematic provisions, including those on maintaining worker pay and benefits for employees who miss time based on potential exposure or infection diagnoses. So we'll have to stay tuned for that. But in the meantime, I would expect OSHA, as it continues to develop this delayed emergency temporary standard, to perhaps make some of the CDC guidance we've seen mandatory, look to its January 29th publication about protecting workers for some of those provisions. They listed, I think, 16 items that they think make up the best type of emergency response plan, COVID-19 response plan. And they also may look to California, Oregon, Michigan, and Virginia. The first three have ETSs basically in place. Virginia had an ETS and now has issued a final standard. So I'm sure that OSHA will be looking to those as examples too. If we can go to the next slide. While we wait on that ETS, on March 12th, OSHA announced a national emphasis program, and the stated purpose is to ensure that employees in high hazard industries or work tasks are protected from the hazard of contracting COVID-19. And you'll see there some listed industries. They're going to focus on preventing and punishing retaliation against workers who are complaining about unsafe COVID-19 conditions. And it's interesting. This shows that despite an acknowledged light at the end of the tunnel and the potential for increasing vaccination, President Biden has talked about all adults who want a vaccination should be able to get it by the end of May. OSHA does look like it'll continue to use its current tools to address alleged violations of COVID-19 related to COVID-19, and they've done that so far through their respiratory standard, reporting and record keeping, and PPE standards. They could also increase usage of the general duty clause, which is, basically employers need to provide a safe workplace, and that's 5A1 of the Osha Act. Again, when it comes to the preventing and punishing retaliation, it looks like they're looking to push folks to encourage whistleblowers, and they promise prompt referral to the Whistleblower Protection Program. So again, I don't think the NEP is going to replace the ETS, but it's something to look at in the meantime. If we could go 2 more slides past the OSHA enforcement placeholder and into the no assistant secretary yet slide. I'll wait on that, but that talks about the current leadership. Kevin also discussed current leadership in the wage and hour division. Here we have James Frederick is the principal deputy assistant secretary. Mandy Edens is the deputy assistant secretary. She's a career person who's been around for a long time. Joseph Hughes, deputy assistant secretary for pandemic and emergency response. Leah Ford is the chief of staff, and my old boss in the OSH division, the occupational safety and health division of the solicitor's office, Ann Rosenthal is the senior advisor. Can we move forward a couple slides? We're having trouble with the deck. All right, keep going. Next one. Yeah, so I just talked about these current folks in leadership positions. Again, we don't have a assistant secretary, similar to the wage and hour division not having an administrator. But these folks, Mandy's been around since 1985. Jim Frederick and Chip Hughes both have extensive union experience, and Chip Hughes has extensive disaster response experience. Leah Ford is a former union organizer and an attorney. So these are definitely folks who, as Dawn mentioned, have union experience and are sort of making good on President Biden's promise to be the most union-friendly administration in history. And if you go to the next slide, just a list there of the top 10 OSHA violations in FY 2016. So the last time under the Obama administration. Actually, these didn't change that much in FY 2019, which is the most recent exposure or inspection information for the Trump administration. There were actually 33,393 inspections in 2019, so more. I don't think that's what's going to happen. I think we're going to see more enforcement activities, and we're going to see a focus on complicated, complex high dollar value, high exposure, what OSHA refers to as egregious cases. If we move to the next slide, just speaking about publicity, those of you who are fans of our webinars have seen this quote before from Dr. Michaels. I, again, expect OSHA has already pulled back on the publicity aspect that Trump sort of curtailed, the Trump administration curtailed, and will likely issue press releases when violations occur rather than when they become final orders. A lot of us refer to that as public shaming, and I think we will see more of that. If we could go to the next slide and then the slide after. Just very quickly on vaccines, which I know a lot of people are interested in. OSHA has never mandated vaccines. I don't think they'll do that, but they have said employers can mandate. You may get into whistleblower 11C issues of the Osha Act, and there may also be implications under the General Duty Clause 5A1 that I mentioned previously. The closest OSHA has gotten in the past to mandating vaccines is under the bloodborne pathogen standard, where hepatitis B vaccines need to be offered to certain employees, but they're not mandated and employees can decline. So that is it. If we go to the last slide on thanking you for attending, we really appreciate the participation of our webinar attendees today. Lots of great information from my colleagues. Thank you so much to Annette, Kevin, and Dawn for sharing their insights. Again, we'll work to answer any remaining questions that weren't addressed that were submitted in the chat, but please feel free to reach out directly to your friendly neighborhood Seyfarth attorney with any additional questions, and keep an eye out for additional content on our firm website, including our podcasts. There is what I've heard is the best one ever by Kevin and me on the paid program that Kevin mentioned before. We discussed paid and what employers, good faith employers should do now. And we also have the Policy Matters newsletter spearheaded by our wonderful colleague, Scott Mallory, out of our Sacramento office, a former political consultant who knows what's going on the inside. The other thing, one more programming note, we'll have another webinar in this series on May 4th at 2 p.m. Eastern to sort of mark President Biden's first 100 days. So be sure to keep an eye out for that invitation. Thanks again, and have a great day.